This case starts quietly, but don't be fooled. Julia Wade stands before the court after admitting to aggravated perjury, a third-degree felony tied to a lie that may have protected a murderer. On the surface, the defense paints her as a first-time offender, a hard-working single mother asking for a second chance. But beneath that plea is a far more disturbing question. Did this lie help keep a killer free? Stay with us, because what the prosecutor reveals and how the judge responds changes everything.
Good morning. You're Jaleisha Wade, and Ms. Wade was previously in court, entered a plea of guilty to aggravated perjury. The agreement was for probation. The length of time and type of probation was all left up to the court. Is that correct?
Yes, Your Honor.
And I've received that pre-sentence report, as well as some letters that the defense counsel has provided of support for Ms. Wade. Has everyone had an opportunity to review all of that?
Yes, Your Honor.
Are there any additions or corrections to that pre-sentence report?
The only correction, it stated that Mrs. Wade's driver's license had expired, but it expires in 2030. So her driver's license is good. So that's the only.
Okay. Mr. Coleman?
Nothing with regard to the PSI, just a brief argument. It is on the court's ready to hear.
Sure. Ms. Holmes, I'll let you go ahead with the argument.
Yes, Your Honor. Thank you. Your Honor, I've had the opportunity to speak with Ms. Wade on several occasions, and in regards to this aggravated perjury, this is a third-degree felony. Ms. Wade, prior to this happening, has no criminal history, zero criminal history. The only thing is on the date of this incident at this trail ride, Zydeco, she was in an altercation with a young lady in which she was charged with an assault, in which she has successfully completed deferred adjudication for the misdemeanor. She has no felony criminal history. She understands the ramifications of being untruthful in regards to who she was in a car with. She was the passenger in a vehicle, and that is what she was indicted for, as to being untruthful as to who all was in this vehicle that she was a passenger in. Your Honor, we understand when testifying, when she was subpoenaed to testify in front of this grand jury, that we need to be truthful, and she understands that. And moving forward, she wants that opportunity to show that she can be, obviously, continue to be a productive citizen in society, and she's asking for that second chance. We are obviously asking for a deferred adjudication in this matter. We believe that this is a case that should be afforded that opportunity for Ms. Wade. She is a single parent who provides for her son. She works hard. She has, as I stated, no other history. And as you can see on the evaluation in this PSI, it's indicate a low risk level, which we feel is very important for the court to know, because it suggests that offenders who are rated as low often self-correct. And we believe that Ms. Wade will self-correct and understand her actions moving forward in life, but we do want her to have that second chance to be able to complete a deferred adjudication so she does not have a felony conviction on her record. We know that this is a court of second chances. We've seen several times people who I believe sometimes have more heinous crimes that get the opportunity at deferred adjudicated probation. And I believe that Ms. Wade should have that opportunity as well. We do know that obviously short decision, Your Honor, in regards to that, and in regards to the length of time, being that this is a third-degree felony, we are asking if the court grants Ms. Wade this deferred adjudication, if it could be in the range of possibly 3 to 5 years, as opposed to the maximum 10. It states that she lacks prior felony convictions that suggest that this incident may represent an aberration rather than a pattern of criminal behavior. In addition, it states in this PSI that her stable employment, parental responsibilities, and minimal prior criminal records support the feasibility of probation as a means to rehabilitate rather than to punish. And we feel like having a straight probation will be more of a punishment rather than a rehabilitation, so that she can self-correct and be productive and have that opportunity to move forward in life without this conviction. So, Your Honor, we are asking for a deferred adjudication in the range of 3 to 5 years if possible, so that Ms. Wade can prove that this will not happen again.
Thank you, Ms. Holmes. Mr. Coleman?
Your Honor, Ms. Holmes characterized her lie to the grand jury as just simply a lie about being in who she was in the car with. She lied about being in the car with someone who law enforcement strongly suspects had just shot up an innocent man at a Zydeco.
This is where the tone of the courtroom shifts completely. Up until now, the defense has framed this as a simple lie, a mistake made under pressure. But listen carefully to the prosecutor's argument. This wasn't just about who was in a car. Law enforcement believes this lie shielded someone suspected of shooting and killing an innocent man. In legal terms, that's why aggravated perjury carries such weight, because false testimony can derail justice, delay closure for a victim's family, and potentially allow violent offenders to walk free. The prosecutor is also walking a careful line here. He admits probation is on the table, but he's making it clear that leniency comes at a moral cost. So here's the real question for viewers. If a lie blocks justice in a murder investigation, should a clean record still matter?
Trail ride, rodeo, arena. That's what she lied about, Judge. Law enforcement suspects and has good information that she was present when this innocent man was shot by this suspect who she lied about riding in the car with. Law enforcement has good reason to believe, and I believe as well, that she holds the key, has information that could bring that family of the defendant some justice, some closure, and help solve that unsolved murder and prosecute the person that's responsible for it, Judge. The nature and the gravity of this offense requires, Judge, it pains me to even have to offer probation, Judge, but there are certain realities that I have to deal with and that necessitate me making this offer of probation. That family has to live with the loss of their loved one and possibly that crime not being solved. And if they can live with that, Judge, this defendant can live with a felony conviction on her record for not, in my opinion, being completely truthful, providing all the information that she has. It is tantamount to obstruction or hindering a prosecution what this defendant has done and what she continues to do, Judge. She's fortunate that all I can do at this point is offer straight post-conviction probation and not tear up with your I am imploring the court, please, to put her on a straight probation, post-conviction probation, Judge, with as many conditions as the court sees fit.
So, Ms. Wade, I don't know if you've been in here all morning, but I've had a couple of tough sentencings. The information that you he's right. You know, we're not just talking about some crime, we're talking about a murder that you lied about. That still, when maybe never will be resolved. So I understand and agree with Mr. Coleman. The other side of that, other than that day, you've never been in trouble. And I don't know if there's a fear, if there's someone pressuring you, or those types of things, which I wouldn't be surprised of based on the people that we were dealing with regard to that murder charge. Ms. Holmes is correct, though, that, there are offers and agreements every day in here for worse offenses, where I do give deferred probation, where people actually shoot people in aggravated assaults and things like that, and robberies. All right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to give you an opportunity today and defer all proceedings and place you on probation. I am going to place you on probation for 10 years. So Ms. Holmes gets part of what she wants, and hopefully Mr. Coleman will feel a little more secure knowing that you will be under probation's watch for up to 10 years. I am going to order a $1,000 fine, order that you follow all of the rules and conditions of probation. Now, that is going to include, and I don't know what relationship you had with anyone that was in that vehicle, but you will be ordered as a condition of your probation to have no contact or communication with any of them. That includes John Gutierrez and Shamar Johnson and Patrick Charles. Okay, are those the three?
Yes, sir.
Can I say something? Shamar Johnson is, we have the same niece.
They're related.
We're related.
Okay. We can't go to family members. You can't be around them right now until I give you permission to be around them. So if there's a family get-together, one of you gets to go and one of you doesn't. That's part of the consequences of your actions. Okay? He was in the truck also, and I don't know what he knows or did, but obviously everybody that was in that vehicle probably has some information about something terrible that happened that day. Otherwise, there wouldn't have been the lies told. So you don't get to be around him, period. Do you understand? Okay. If you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you do not have a felony conviction on your record. Oh, sorry. And if you successfully complete the probation, then you will never have a felony conviction. The case will be dismissed. The other side of that, however, is if you violate any condition of probation at all, you'll be brought back into court and you could be found guilty and you could be sent to prison for up to 10 years. Do you understand? Yes, sir.
Sorry to interrupt, Your Honor. Would the court entertain or at least consider some jail time as a condition of his probation? And if any of the alternative.
In the end, the judge delivers a sentence that reflects both sides of this case. Julia Wade avoids an immediate felony conviction, but the consequences are serious. 10 years of deferred probation, strict conditions, no contact with key individuals, and zero tolerance for violations. The judge makes it crystal clear, this is her one and only chance. One mistake and prison is back on the table for up to a decade. This ruling highlights a critical balance in the justice system. Mercy paired with accountability. Deferred probation isn't freedom, it's supervision under a microscope. Now we want to hear from you. Did the judge strike the right balance here? Or should the sentence have been harsher given the gravity of the lie? If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Maybe a condition of serving at least 1 day or 1 weekend in jail on the anniversary of the death of the victim in this case.
I'm sorry, Your Honor. She is not charged with murder.
Hold on. I'm not, here's the thing, Miss, hold on, it's fine. Miss, I appreciate, that Miss Richards is, I'm not going to put her in jail today, she's taking care of a child. But here's the thing, Miss Richards, some people, I'm sorry, wrong, Miss Wade, I was looking at the wrong thing, Miss Wade. A lot of people, and Miss Holmes can tell you this, there was a time, where I would give probation. People would come back, they'd mess up. Sometimes I'm given some extra chances. Those days are gone. This is your chance. This is your chance. So if you violate, I can assure you that if we're standing in here, this man right here is going to remind me of what I should have done the first time with the conviction and possibly prison or send you to jail up front. So you need to do everything you're supposed to. Follow all of the rules, and if you do that, again, this is your opportunity to put this behind you, continue living your life like it looks like the rest of the way you've been living it, other than on that day, hopefully. Right? Makes sense? Did I already hand you? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork.
I do have a question. She lives in Texas City, I believe that's Galveston County. Will she have the opportunity to transfer?
Talk to probation today when she calls you up about where you live, and they'll have to do the appropriate paperwork, and it'll be transferred to where you live. Okay?